It is July 15th of 2026, and this is the Court Gallery. Coming up, we kick things off with a man representing himself who fully admits to speeding, but argues it was a necessary safety measure to get away from the very officer who was pulling him over. Then, the proceedings take a strange turn when a judge asks a woman why she's neglected taking care of a 21-year-old ticket, and her answer is so brutally honest, it stops the entire courtroom cold. And finally, just when you think you've heard it all, a final hearing over simple fines devolves into a full-blown showdown over a mysterious litigation. But it's the ringing cell phone that really has Judge McNally ticked off. Stay tuned. All that and more starts right now.
Will now be on the record in BU 2025 TR 2814, State of Kansas versus Sven Martin St. Peter. Jared Regier for the state. Mr. St. Peter appears in person and pro se. Sir, you're charged with one count of speeding 78 and a 65. We are set for bench trial. I see you have filed a motion for, looks like, motion for discovery back in June. Are you ready to proceed, Mr. St. Peter?
Yes, Your Honor.
And Mr. Regier, are you ready to proceed?
At the court's leisure, Your Honor.
All right. Again, this is a trial on speeding 70. I may have said 70, but now that I'm looking again, it's 78 to 65 on December 20th to 25. So, Mr. Regier, please call your first witness.
Thank you, Your Honor. Upon waiver of opening argument, the state would call Master Trooper Troy Setzkorn to the stand.
Trooper, please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
Thank you. You may lower your hand. Mr. Regier, you may inquire.
Thank you, Your Honor. Would you please state your name for the record?
Troy Setzkorn.
And where are you employed?
With the Kansas Highway Patrol.
And what is your professional title with the Kansas Highway Patrol?
I'm a Master Trooper with them.
How long have you worked as a law enforcement officer?
I started with the Highway Patrol in July of 14. I had 4 years of experience with Cali County prior to that.
So approximately 16 years of law enforcement experience all told?
That is correct.
Were you on active duty in your professional capacity on December 20th, 2025 at approximately 7:07 p.m.?
I was.
And where are you at that time?
I was traveling southbound on US 77 at approximately milepost 35.
And is that in Butler County?
That is.
Were you driving in a vehicle at the time?
I was.
Please describe this vehicle for the court.
It was a 2019 Chevy Tahoe.
Okay. Are there any indicia or on the outside of this Tahoe to identify it as a law enforcement vehicle?
Yes, it is marked on all sides with state trooper or badges.
Okay. Could you please describe your immediate surroundings for the court at the time as you recall them?
US 77 highway is a 2-lane highway for north and southbound travel, wide shoulders.
Okay. Overall, would you describe this as a more rural or urban area?
It's a rural area.
Okay. Now, you mentioned that US 77 is a highway. Is that a state or federal highway?
It's a federal highway.
Okay. At this location, is US 77 more curving or more of a straight shot?
More of a straight shot.
Okay. What was the weather like at the time, do you recall?
It was dark. I don't remember the temperature. I don't believe there was much for wind.
Okay. Do you recall anything about the situation to suggest there was inclement weather at the time?
There was no inclement weather.
Okay. Are you familiar with KSA 8-1558?
I am.
And what does that say about drivers and maximum speeds?
Maximum speed limit was 65 miles per hour.
Okay. And these speed limits that you refer to, is a specific class of drivers expected to comply with it?
Not sure I understand your question.
Yeah, are any particular groups of drivers exempt from complying with the speed limit that you're aware of?
None that I'm aware of.
Okay. Your Honor, at this time, I respectfully request the court take judicial notice of KSA 8-1558.
Lincoln,
That's true, but do you consider yourself capable of identifying traffic violations on site?
I do.
Could you please describe any training or past experiences you might have that allows you to identify traffic violations in this manner?
Coming out of the academy, it was 6 months of training on how to identify violations. After that, there's another 6 months approximately of field training that you go through to identify violations, and then just experience in the last 16 years of identifying violations on a daily basis.
Okay. Do you have any continuing education obligations that you're expected to complete to maintain your certification as a law enforcement officer?
Every year we have 40 hours of continuing education to maintain our law enforcement certification.
Okay.
As far as radar is concerned, we also have a 2-year recertification on that.
Okay. And are you current on your continuing education obligations at this time?
I am.
Okay. On December 20th, 2025 at approximately 7:07 p.m., did you see any acts that you consider traffic violations?
I did.
What did you see?
I saw a vehicle traveling northbound on 77, appeared to be moving faster than the posted speed limit of 65. I activated my radar and found the speed to be 78 miles an hour, and I locked the radar at that speed.
How could you have seen this particular traffic violation if it was approximately 7:07 p.m. in December?
It was the headlights that I saw coming at me.
Okay. So is it your testimony that you identified this violation based off of you observing the vehicle with your headlights activated?
That is correct.
Okay. Can you please describe this vehicle for the court?
It was a red Chevy pickup.
Okay. Now, you previously referred to radar. Is it your testimony that you use this specialized equipment to check this Chevrolet speed?
That is correct.
Okay. And you also had referred to a 2-year radar certification program. Are you certified personally to use this equipment?
I am.
Okay. Do you use testing on the stalker radar to check that it's working properly?
Every day.
Every day? All right. And what does this testing entail specifically?
This is an internal test within the radar. So at the beginning of your shift, you'll run that internal test, and then you'll run that internal test again at the end of your shift. It will diagnose any problems within the radar.
Okay. Does stalker radar require daylight to work properly?
It does not.
How do you know that?
It works at night just as well.
Okay. Have you ever had any experiences to suggest that that might not be the case?
I have not.
Okay. Suppose that this testing resulted in finding that the stalker radar was not working properly. What would happen then?
The device will render itself unavailable. It can't be used until it gets turned into the company to be fixed.
Okay. Can you confirm that the stalker radar that you were using on the date and time in question was working properly?
I can.
And how do you know that?
Because I tested it that morning and I tested it that evening, and both tests were passed.
Okay. Can you confirm that this Chevrolet you referred to was specifically clocked by the stalker radar?
I can, as it was the only vehicle in front of me.
Okay. And you've mentioned this already, but for the record, what is the posted speed where you were at?
65 miles an hour.
And the speed that the stalker radar measured the Chevrolet driving at?
78 miles an hour.
Did you ever successfully conduct a traffic stop on the Chevrolet?
I did.
Once you conducted the stop, did you personally speak to the driver of the Chevrolet?
I did.
Do you see that driver present in the Zoom conference?
I do.
Can you please point them out and give a brief description for the court?
Short hair, looks like a blue shirt, white male.
Your Honor, let the record reflect that the witness has identified the defendant.
The record shall so reflect.
Master Trooper, during the stop, did the defendant ever provide you with any official identification?
He did.
What was this official identification, if you recall?
He provided me his Kansas driver's license.
Did you ever discuss the defendant speeding with the defendant?
I advised him of the speed. He advised that the truck was, I believe he called it, it was uncle's truck, and he was not used to all of the gadgets on it.
Okay. Did you ever write the defendant a citation for speeding?
I did write the citation for speeding.
Okay. All right, and redirect, no further questions, Your Honor.
All right, Mr. St. Peter, you may cross-examine this witness that is asking any questions in response to what he's testified to. It's not yet your time to testify, should you wish to, but if you have questions of the trooper, now is your chance to ask them. And I'm not hearing you, sir. Can you click on that little red microphone that, if you're on your
Sorry
tab-
about that.
No problem.
Sorry about that. So I only have one question. Twice in the history, which is impressive, and I have nothing but the utmost respect for you, sir. So I was wondering, the police officer, I was wondering what is the significance of the 707? Mr. Regier brought it up twice. It's also what you wrote on the speeding citation. So what does that mean to you, the 707?
I'm not sure what you're referring to as the 707. Are you talking about the time of day?
Yes, it was. I think it was 7:07 p.m. was on the traffic citation, and Mr. Regier brought it up twice when he spoke to you. What does that mean to you when that is brought up?
It just means that it was dark outside.
No, I mean, as to when you write it on the citation, you put this date, this location, 7:07. Is that the time you recorded the speed? What does that mean?
That's the time that the speed was recorded, yes.
Okay, that's all I have, Your Honor.
Well, I show the ticket was issued at 1907, which is that the 707?
Yes, that's 7:07 p.m. military
Okay.
time.
I knew that. I just wasn't sure if you knew that because everybody's saying 707. It's like, well, he technically wrote down 1907. All right. Any other questions, Mr. St. Peter?
No, Your Honor, that's all. The only question I had.
Okay. Thank you, Mr. Regier. Any redirect?
No, Your Honor.
Any other witnesses or evidence, Mr. Regier?
No, Your Honor.
The state would rest.
State does so rest, Your Honor.
All right, Mr. St. Peter, they've presented all they're going to. Do you have any evidence you want to present? You don't have to. You can remain silent, and that silence will not be used as evidence of guilt. But if you want to testify, this is your opportunity.
So it won't be very long, maybe about 5
All right,
minutes.
then
May I show a quick video?
Yes, but do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, thank you. And you are Sven Martin St. Peter, the defendant herein?
Yes, Your Honor.
All right. Now, what would you like the court to consider?
I have the camera, the dash cam of the trooper's car, and just a couple of reports that will show why I was speeding. I'm not denying that I was speeding, but I will, when you see the video and see what happens, it will show you why I was speeding.
All right, let's call the dash cam Defendant's Exhibit A. Now, do you have that available where you can play it, sir?
Yes.
You don't have a screen share? Is that what you want to do?
Yes, Your Honor. I'd like to share
All
my
right.
screen.
And I think Clerk Jenny, you're going to have to enable it so he can screen share.
Yes, give me just a second.
And Your Honor,
Mr. Regier?
the state would make inquiry if, while the state does acknowledge that discovery was provided to my office following the defendant's motion in this matter, the state would have concerns as to how to determine whether or not any of these alleged items seemingly proffered by the defendant are still in their original form or have been altered in some fashion.
Yeah, you'll need to probably introduce this through the trooper to have him identify that it is his dash cam and ask him if it's the same as it was when it was recording.
Of course, Your Honor. And it came off the portal that when you pay the $25 fee and they send it to you. So I can provide those and I think you will see that it's his car.
I'm going to take your word for it that that's how you got them. Mr. Regier will know if you didn't, but you still, one of you needs, you or the whoever's calling the evidence needs to show me that it is what it's supposed to be. And so, well, you want to call the trooper to introduce that, maybe put it up on the screen and have him confirm that it is his dash cam?
Yes, Your Honor. Am I ready to share? Let me see if I can do
You
this.
are, you should be.
Okay. Let me know when you see the screen. Does it show it right now?
No.
Let's see. Oh wait, let me hit the share button.
Now it looks like it's loading. It says double click to enter full screen mode. I think that's you.
Oh,
Okay.
let's see here. Is it full screen for you guys or not?
It is. It is.
Okay.
All right. Now you're going to call first before you testify. You're going to call the trooper to introduce his dash cam. Is that right?
Yes.
All right, Trooper, you're still under oath. So please proceed, Mr. St. Peter.
I wonder, is it Trooper Setcorn? Do you see the screen? I know it's hard until I play to actually completely verify that it's your car. And it says on the bottom it was supplied by, I guess, the KHP, but does it look like your video off your vehicle?
I would be hard pressed until we play it.
Okay. Should I go ahead and play it, Your Honor?
I will note for the record that I am seeing what looks like a car light shining onto a highway, a two-lane highway in the dark. And the bottom of the video says cruiser dash cam Troy Setcorn, and then it has number 2025 1220 193, I think. My eyes aren't good enough.
Yeah, that's correct. 1903, yeah.
Okay. So this is what I'm looking at. In Trooper Setcorn, you can't tell if that is yours or not until you see it run. Is that what you said?
I would be better able to say whether or not it's my video after it's played.
Yes, I would agree with that. Just real quick, I'm starting at it started at 0. I'm starting at 39 seconds so I don't waste the court's time. The vehicle coming up that you see with the two little lights there, that's mine. And so I'm going to go ahead.
You're testifying. Let's play the video through him, and then you can address it. Okay. So let's go ahead.
Go ahead and play it. Okay. Here we go. Something I want you to see is I'm fumbling with the brights because it's my own.
Stop, sir. Or what? This is his testimony. We'll get back to you.
Oh, okay. Sorry. Let me go back.
I understand.
Now I understand what you meant. Now I get it. Yeah, I'm sorry about that, Your Honor. Go ahead. I'm going to play it. Here you go. That's all I needed to play.
All right, now ask the trooper if he recognizes that.
Sir, is that your dash cam video?
That does appear to be consistent with my dash cam.
Thank you,
All
sir.
right. Any other questions of this witness, Mr. St. Peter?
I guess I need to go through the reason I asked.
He's your witness. Remember that.
Oh, I see what you're saying.
If you want to call him for any other purpose.
Can I share, as I'm asking the questions, can I share additional information?
Meaning you want to replay that, or you want to?
No, I need to present something else.
You can try, and if there's an objection, I'll deal with it.
Okay. So this is all from, these documents are all from the, so here's the call history log. I received that at the same time.
Your Honor, not foundation and hearsay.
Sustained.
Again, I received that at the same time when I paid the $25, so I don't know what the objection is, but it's very important to my case, otherwise I can't prove the 707.
Well, sir, if you're going to represent yourself, you're held to the same standards as an attorney if you don't want to hire an attorney. And an attorney couldn't bring in evidence without the person that prepared that report. Mr. Regier couldn't just bring it in. You can't just bring it in, even if you got it from Mr. Regier. So,
Okay.
now, if you want to ask Trooper Setscorn something that might help you,
Okay.
you're welcome to.
Okay, well, so Officer Setscorn, when you first call in your when you see something happen, like you see somebody speeding and you call it in, would that be considered like, it's called like en route or like starting of the process? Is that correct? I don't know if I'm wording that correctly, but like when you make the call in to wherever the call records are recorded, is when you say en route and on scene, is what does that mean? Does that mean you have found somebody that you saw
Why don't you
speeding?
just ask him what that means instead of trying to tell him what you think it means?
I thought that's what I was doing, but yes. May I know what that means to you?
So our system with the en route and on scene time for this particular type of incident, it would be the same time. The en route time would be more if I was responding to a call for service, and then there would be an on scene time when I arrived. For this, I'm basically on scene and en route at the same time, so those times would be the same.
Yes. Okay. So I know, I guess I was told, so would the en route time be the same as the when you record the speed, like on the ticket, on the speeding ticket, would those always be the same?
No, there's going to be a difference of time. For the time I get on the radio, I'm not writing a ticket while I'm actively making a traffic stop. So when I make radio traffic would be before I wrote the ticket.
Okay. So as you were watching the video, you noticed that you came up like very close behind me, and at that time, so you're correct. I mean, as you stated, it was dark.
Your Honor, testifying on direct.
Sustained. You have to ask him questions.
Okay. When you told you said during your testimony that you recorded my speed as I was coming from the opposite direction. May I ask, how come when you turned, you didn't engage your emergency lights indicating that you had saw me speeding?
That is our procedure, is to go up and identify the vehicle before we activate our lights. So at nighttime, I'm going the opposite way. When, as you saw in the video, that my headlights, the high beams came on. I was fumbling with it, which I believe you said I explained to you when the gadgets, right? Is that correct? You mentioned that it was not your truck. You had an older truck and you weren't familiar with all the buttons on this one. Yes.
Exactly. So on the video, it shows that I flashed the high beams as you came,
Objection, Your
as I
Honor,
came around.
testifying on direct.
Ah, yeah. Sorry, I'm trying to figure this out. Okay, so anyway, did you see on the video that I flashed the high beams?
Yes.
Okay. When you came up behind me and it being night, did you assume I knew you were a police officer?
I didn't make any assumption.
Okay. I guess at this point, Your Honor, I'm done asking questions. I just need to state at some point why I was what I believe.
No further questions of this witness. Mr. Regier, any cross-examination?
No, Your Honor.
All right. Then this witness may be excused, counsel, or he can stay if he wishes.
Your Honor,
back-
the state would respectfully request that Trooper Setskorin remain on in the event of a prospective rebuttal witness.
Very well, Trooper, I'm going to have to ask you to stay a while. But Mr. St. Peter, do you have anyone else, including yourself, that you want to testify at this time?
No. Your Honor, I know, may I
Oh,
show
now hold up.
something?
You keep
Your
telling
Honor.
me that you keep telling me, sir, that there's something you want to say. This is your chance to say it. Are you sure you don't want to testify? Which just means tell me what you want me to know under oath.
Oh, yes, I do want to testify.
Okay. All right. Well, please raise your right hand then. I can't remember. It seems like I swore you in, but you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, Your Honor.
Now you may lower your hand. I remember I swore you in and I thought you were going to testify, but then you needed to see the video. Okay. So if you want to replay the video for your testimony, whatever you want to do, tell me what you want me to consider. And if it's objectionable, Mr. Regier most likely will file that objection and then I'll respond.
Okay. May I bring up one more document that I made just so it more clearly explains what I'm trying to say? It has nothing to do with, it's something I made.
It's a document you made in preparation for court to help explain your testimony?
Yes, Your Honor.
Your Honor, the state would object to this exhibit as the state has not received it, and as discovery was received by the defendant in this case, the state does have a right to expect the same discovery of the defense upon being triggered of the appropriate criminal discovery statute.
All right. Well, we try to do what we can to make discovery possible because of the Zoom. If we have to kind of, whoever, Jenna, please put Mr. St. Peter, Mr. Regier, and me in a breakout room so Mr. Regier can look at the exhibit before it's introduced, and so I can rule on any objections he might have. Or Mr. Regier, do you want to go in the breakout room without me present? That's okay too. I agree you're entitled to see what he's going to present.
Your Honor,
But
say has no objection to the court joining if the court determines that is procedurally appropriate.
All right, let's go in a breakout room. Well, we don't have a jury. I'm the trier of the fact. Just go in a breakout room, Mr. St. Peter. Show him what you're going to introduce, and then come right back out. Don't engage in any big discussion where you're going to get crossways with each other.
Very good, Your Honor.
Mr. St. Peter, you still wish to present your drawing or your diagram or whatever it is?
Yeah, I thought that's what I was doing, but then I noticed I was in the room by myself.
Mr. Regier, you didn't go in there with him?
I did, Your Honor.
Did you see what he was wanting to show you?
I did, Your Honor.
Do you have any objection to it?
Yes, Your Honor.
What is your objection?
Your Honor, the state's objection is on three grounds. First off, hearsay as well as foundation, as that has not been properly established in this matter. Additionally, the state would be objecting on grounds of relevance, as well as relevant evidence is defined under KSA 6401B as evidence having a tendency to prove any material fact, and the state does not consider the prospective exhibit if the court indeed admits it to include any relevant evidence to the issue of whether or or not the defendant was speeding in this matter.
All right. I don't know what the exhibit is. You're going to have to screenshot it for me so I can see what it is to make a determination on relevance. As far as hearsay, I understand, Mr. St. Peter, you're the one that prepared the report. Does it involve statements of people that made out of court that aren't here today?
Absolutely not.
And I understand the foundation is he made it himself. Well, for what purpose is it going to show me? What purpose is your diagram going to be admitted?
It's going to show you that I feared for my safety,
And
which was the reason for the speed. I was trying to get to it's completely dark there. There's no people, there's no anything, and I did not know
Your
there was a
Honor,
police
objection,
officer.
testifying while not under oath.
he's
She
under
asked
oath.
me.
He's under oath. Okay. So, well, the reason I think it's not relevant to if you were speeding is I don't believe that is a legal defense to speeding. Speeding is
My
kind of
safety, if the vehicle behind me doesn't have lights and sirens on and I fear for my life, I'm not allowed to take whatever measures needed to feel safe. I don't know what you would do. What would you do?
I might violate the law too. I don't know. But I do know there's not an exception for speeding that says if your life is in danger, you may, or it's kind of a strict liability. If you do it, you're liable.
Right.
And I've heard a lot of
Well-
situations where I thought, yeah, that makes sense, but the statute just does not say that's up to me to decide. My job is to decide, was he speeding or wasn't he speeding, not why was he speeding. And that's why Mr. Regier is arguing irrelevant, because your reason for speeding doesn't matter. I've heard a lot of reasons that I thought, yeah, I might speed if I were in your position too, but again, that doesn't make it legal.
Even if you fear for your life, like if I felt my life was in danger, I mean, I guess if it's okay to put my life in danger and I'm not allowed to counter it, I mean, gosh, if somebody comes to your home and your life is in danger.
Objection, Your Honor, relevance. This is not a case that involves a residence.
Yeah, I being in your home has there are rules that let you defend in your home. But when you go out onto a public street, you have to follow the public rules. And if you don't, then I have to make a determination when the state says you didn't. Did you or didn't you? But why you did it, no, I've heard like I said, a lot of good reasons why people did violate the law, perhaps, but they're not allowed to, because say you were speeding to protect yourself or speeding to get away from somebody, you may create more damage by speeding or more danger to people and yourself by speeding than not speeding. So, yeah, I'm going to sustain the relevancy argument if it's being offered to show that why you were speeding.
May I show you the screenshot though? Because there's
Objection, Your Honor. The court has already ruled on admissibility.
No, she hasn't.
Yeah, I've ruled it's inadmissible because of relevance, because I don't believe why you were speeding was relevant now.
But it also would show the speed and distance behind what could happen. That's
Objection,
not relevant.
Your Honor.
Either.
The court has already ruled on admissibility.
That's fine. It's okay. However this goes, then I'll just go through a civil matter because
well, you can always appeal it. If it doesn't go the way you want, you can always appeal it to the Kansas Court of Appeals. All right, so that document isn't coming in. Do you have anything else you want to testify to or present?
You know, it would be nice that if there's some kind of, like, if you defend yourself, like the gentleman beforehand that says, hey, I don't have the money and all that, a little bit more guidelines. Because I called Mr. Regier's office and he didn't give me the time of day. So it doesn't matter. It seems like it's set up for failure from the very beginning. And not everybody can afford an attorney. So that's fine. I guess at this point, I rest.
I'll tell you what,
it's not set up to win, obviously.
Well, sir, if you want to present your document to preserve it for appeal, I will let you do that. I think that's fair. So the Court of Appeals can see what it was, whether it should have come in or not. And that would probably be the issue on appeal. But you're presupposing, and I'm finding you guilty, and I haven't made that decision yet. I do that after I hear all the evidence from both sides.
And Your Honor, if
So-
the court is going to give the defendant this degree of latitude, the state is seeking assurance on the record that, as the court has already ruled on admissibility, that it will not be considered in whatever verdict the court reaches.
I'm going to let him. Do you want to make that a part of this record for appeal or not?
No, I have one more question, and it could be to Mr. Regier.
No,
When the
no,
trooper-
no, the
No?
trooper.
Okay,
You don't ask
Okay.
Mr. Let me make sure I understood what you were saying. Your question does not go to Mr. Regier, but if you have a question for the witness, you may ask it.
okay. Let me think for just a second. Uh,
Do you want some
no,
time? You want
it's
to,
no, it's okay. I
do
just
you want to continue?
no, it's just really sad because I'm if I do something wrong, I always take responsibility, and in this case,
Hang
it's
on.
not about the money or whatever, so it's okay. Go ahead, and I'm just gonna rest.
I was just going to say, if you wanted or need a continuance to find an attorney, to talk to an attorney, I don't usually split these hearings, bifurcate them as it's called, but I would do that to allow you the opportunity to get a witness and to hear whatever you need to hear. I'd be willing to do that, Mr. St. Peter.
I appreciate that, Your Honor. No, it's okay.
And Your Honor, the state would be objecting to any continuances, as the state has already presented its case in chief and the defendant has already had the opportunity for direct examination.
That's fine.
Take further
Yeah,
consideration.
just end it, Your Honor. That's
Let
fine.
me
I don't
finish,
want to
Mr.
hear it no more.
Mr. Setsko, let him finish. I know you don't want to hear it, but let him finish, and then I'll hear from you, sir.
The state.
It's okay. I
Have
rest.
it
Go
noted
ahead,
on
let
the
him know.
record, Your Honor, that it is axiomatic that a defendant who undertakes to represent themselves in a pro se fashion is held to the same standards to any attorney. And in my role as prosecutor, I do not represent the defendant in these proceedings.
Yeah, but you know what? In I work aviation, Your Honor, and one of the huge things is a human factor. And I've tried to contact his office and speak with him, and there's no humanism in it. You get treated like a subpar human being that doesn't know the law. And I get that I don't know the law. All I know is what's in front of me. And, I know different things. So that's fine. At this point, I rest and I defer to you, Your Honor.
Well, I'd sure give you a little more time over his objection. I'm overruling his objection.
I appreciate that. It's
Want
okay.
more time
It's
to
okay.
go out?
I have nothing but the utmost respect for my significant other actually passed away in the line of duty. So this has I have nothing but the utmost respect in this case. I was worried, and I don't drive at night anymore because I had a bad experience while I was deployed, and this happened to be one of those situations where a friend had a flooded basement, and I was on my way home way later than I should have been because I don't drive at night, and so it's okay. I like I said, I'm fine. Thank you, and yeah, if you would it's okay.
All right. You don't have any further evidence, Mr. St. Peter?
No, Your Honor. It's okay. Thank you, though.
All right. Well, Mr. St. Peter, thank you for exercising your right to have a trial, 2% score, and thank you for doing your duties both on the highways and in the courtroom. I find the evidence does support. It does support the finding of 78 and a 65. The officer had his academy studies and his experience that requires him to be able to tell if the car is speeding, but then he has to back that up with his equipment Yes, to show that the equipment is working properly, and he has done that by testing it both before and after the shift. And I am finding the defendant guilty of speeding 78 and a 65. But Mr. St. Peter, I can sure give you some time to pay that if you need it. There's not much I can do, but
No, that's fine. I'll pay everything today, Your Honor. If it's something to do, if I can give like cards numbers over online or whatever, I will gladly pay everything.
okay, you may have to wait until we get a journal entry on file, but call the clerk at the district court and she'll tell you about payment. And her number is 316-322-4370.
And by the way, your clerks are absolutely amazing.
Well,
I have
thank you.
nothing but they're awesome. So thank you for that.
Well, I will thank them for you, and I thank you for finding them to, I don't get to hear enough nice things about them, so thank you. All right, you may go, Mr.
Your
St.
Honor,
They-
I believe there is the specifics of the sentence as well as the prospective appeal.
All right, yes, you do have 14 days to file an appeal with the Kansas Court of Appeals if you believe I have misapplied the evidence or the law and come to a decision inconsistent with those, or whatever grounds that you may find to appeal. But it's not a do-over. You don't start with a new trial like you would if I weren't a lawyer. Some magistrates aren't lawyers, but I am a lawyer, and so magistrates with the law degrees have to be appealed to the Court of Appeals. So
No, I appreciate that.
speaking of my law school days, there was a Nick St. Peter in my law school class. Are you related to him?
You know, I looked into that. I am. There's like a very small line of St. Peter's, and I think you had mentioned a judge as well. There are lines in that tree, so I am not like directly, but like distant cousins or whatever they are in our line. So
Well, we were both in the same small, what they call as sections in law school, and he's gone on, I believe, to be a district judge down in the Winfield area. Has been for a lot longer than I have been. So,
yeah. I tell you that name, you won't believe it, but when I went to basic training at Fort Campbell, Kentucky, in my platoon, there was me, St. Peter, there was a St. Germain, and I kid you not, there was a Lord, a Lord. We were the three holy men, the three wise men, and it was pretty awesome. So,
interesting.
by the way,
And Your Honor, the state would make inquiry as to the court's sentence for purposes of the journal entry.
Did I not say that? Okay. Well, the scheduled fine, maybe that's what I was starting to do, and I got myself sidetracked. But the scheduled fine, I believe, is on the citation. Maybe if not, I looked it up. I know before we started. Let's see. Oh, why don't you just tell me what it is, Mr. Regier? I know you know it.
Your Honor, the state's information is that pursuant to KSA 82118 subsection C, the scheduled fine for this particular offense is $63, and there is also the issue of court costs.
Yes, Mr. St. Peter, the scheduled fine is $63. Court costs are $108. The total due is $171. You said you were going to pay that today, did you tell me, or you're going to
yes, I'll call the clerk's office and pay that today.
She may tell you that you have to wait until we get the journal entry on file, and that might take up to a week, but
Okay.
okay.
Your Honor.
Yes, Jenna.
I'll tell you now. We're already going to tell him to wait till journal entry is, and we won't take a card over the phone. Are you okay if I give him a 30-day overdue hold so his thing doesn't go negative?
Yeah, I don't want anything negative to happen because he exercised his right to a trial, and we don't have the journal entry on file. So,
And Your Honor, does the court wish the 30 days to be reflected in the journal entry or some alternative time?
put it in the journal entry. Jenna, how does he need to word that? I mean, I know you're going to do what you're going to do, but how
It's 30 days to pay, basically. He can pay today if he wants to, but he also has 30 days.
Okay. All right. 30 days to pay. You say he can pay today, but doesn't he have to do that in person?
Yeah, he'll have to come in person if that's the case.
Well, I don't think he wants to do that. Would you tell me you're from?
Yeah. I live in Rose Hill. I think it's about 40 minutes or so. Is that something I can mail in a check, or is it always in person?
You can mail in a check, right, Jenna?
Okay.
Jenna's the
Yep, he can mail in a check, money order a check, never mail actual cash.
No, of course. Yeah.
So
Okay.
you could
Yeah,
put
I will do that.
You could put that in the mail, Mr. St. Peter, and she can hold on to it in her, she's got a special account to hold things if they come in directly. Am I telling him right, Jenna?
Yeah, we'll put it in. He has his own specific financial unapplied account
Yeah.
tied
Okay.
to this case. So if you mail in us a check, the journal entry isn't in, say next week, we will still apply it when the journal entry gets put in, and it won't get lost.
If I have to put the what is it called, the court number or whatever on it?
It's best if you do in the memo line. It helps us
Okay.
tremendously.
Okay, perfect. No, I will get that in the mail then.
Make sure you put your phone number on there, so in case they have any questions, they can call you back.
Will do.
All right. Now,
Thank you, guys.
You're welcome. Mr. Regier, did you figure out what you need for the journal entry? Just put in there with it, has 30 days to pay.
That is the court's order. My office will prepare appropriate paperwork. Beyond thanking Master Trooper Setscorn for honoring his subpoena this afternoon, the state has nothing further.
All right. Thank you all. Mr. St. Peter is excused, and Master Trooper Setscorn is excused as well. Have a good day, gentlemen.
Thank you.
Thank you, Your Honor.
You know, it's interesting. I was a master chief in the military. It's kind of interesting how our worlds coincide and intersect. Safe travels, Master Chief.
A lot of officers do go on to be law enforcement.
That's right. That's right.
Okay,
Thank you, guys.
Gentlemen.
Take care.
We will go on the record in the matter 25 CT 51, State of Wisconsin versus Matthew Swenson. The state appears through District Attorney Kevin Schmidt in person. Mr. Swenson appears in person with his counsel, Bruce Anderson. We're set here today in this matter for a plea and sentencing hearing. Mr. Anderson, can you please state the agreement on the record?
Actually, I didn't bring my computer in today.
On the plea questionnaire, it just says to be determined.
That's because I didn't have my computer with me.
Okay, so would it be the IDIP guidelines for, are you sticking at the BAC 0.323, or is it amended as a part of the agreement to a lower amount?
Well, that's where Tessa spoke with Mr. Swenson, and I realize it's not her call, but she had quoted to Mr. Swenson
Mr. Swenson.
a 45-day jail term, which falls in the guidelines for 0.15 through 0.169.
0.199, actually.
Pardon me?
It's 0.15 to 0.199.
I must have picked up an old guidelines then.
Could have the old guidelines. I'm looking at the new ones.
Oh, I got this out of the bin outside.
They might, I don't know, maybe I have the old one. I don't think so. Nope, because my old one says old, but can you hand me, oh, yeah, can you hand me one from over there? Because I'm out. Or we're out
So
here.
where are you?
Someone took my last one.
This is, I have mine laminated, so I can have it, and this is what I have old and I have new. Oh, wait, from September 2025? No, this is the new one. Yeah. Can I see that one, please? Thank you. We're off the record, sorry. Yeah, these look very old. Oh, no, this says 0.99199. You said 0.169.
There's a newer one.
That's the last one I have. Let me see that.
There's a May 24 one that's distributing too.
Oh, here's the most recent one I have saved. Yeah, I don't have any up here, and I don't have that. 0.19, so.
Isn't there in the 0.15 to 0.169, and then another one right after that?
That's what yours is saying. Must have redid it, and I don't have a new one, so I'm gonna have to get a new one. That's fine. I have this now, so that looks like that. Just looks weird with the printing. Yeah, why do I have that one? I don't, that's the only one I have. It's the very old one, because we have to go, sometimes when they get old, you have to go back to the old dates sometimes and things. Yep, I have that now. All right, I'll just have Tessa make me a new one, laminated new one. All right, back on the record, same appearances as previously noted. All right, so it's a 0.15 to 0.169, and is that the agreement, Mr. Schmidt?
No, I did it at the IDIP guideline. I don't know why Tessa said something different.
So, Mr. Anderson, do you want to speak with Mr. Schmidt
Well,
briefly off the record? Because I know Tessa doesn't have authority. She's not a lawyer. She just does the things.
Right.
But coming in here and then having to enter a plea and be sentenced and hearing that it could be a different sentence, I don't want to have any issues. She can't, off the record. Can you get me a laminated new one? Because I'm guessing Tessa's not here anymore. That's probably why she didn't give me a laminated new one, because she hasn't been here for a year. And you have some Kathy or Kim. I think that's what she, yeah, I think that's what she did. Is she was there. But
I don't know,
maybe
maybe
that's
she
why I
just
don't
missaid
have
it,
a
but
laminated one, because she didn't want to give it to them. So if you could give me the May of 2024. I have a, this is the one that I have, the last one that I was provided that said, yeah. That's very old. Very old. That's like old.
Yeah.
I think the reason it was revised in May of 24 is that's when the district guidelines changed too.
Yeah, that's what I just was looking. You're out, I'm out. I think Mr. Schmidt is out. I think we need more brochures too. Yep. All right. Mr. Anderson, thank you for bringing that to my attention. It's been a little bit harder with communication because Tessa's been at home working all the time. And so usually she's the one that gives me all those things. So back on the record, same appearances as previously noted. Mr. Anderson, were you able to speak with Mr. Swenson?
I have. He understands that any time is going to be at the court's discretion, as well as any other portion of the penalty. And he is prepared to go forward today knowing that.
All right, I have a question before we even proceed with plea and sentencing. If the court orders a fine of, let's just say, $1,911 plus a $10 blood draw, would you be able to pay that all?
Yes.
Okay,
Right away.
all right.
Yes. I take cards, right.
And there's, could be 75 hours or 100, depending, of community service. How do you intend to take care of that? Are you going to do community service, or do you want to convert it to additional jail days? And that would be.
I spoke with, oh, want to go ahead?
No, go
Okay.
ahead.
You go ahead.
Spoke with Teth about that. Obviously I did the 8 hours I had to do for the IDIP program. Obviously.
That doesn't count for the 75.
No, okay.
100.
Yep. All right. And we talked about that, and being the president, I'm president of our snowmobile club and do countless hours of that kind of community service all the time year round. And I know it doesn't go towards this, but I mean, I do quite a bit of it. And like I run the meat raffles for the Webster High School athletics program, help do that once a month for them. So, I mean, I'm always doing community stuff for the thing, is what I talked about with Tessa.
All right, so
Oh, I'm sorry.
you do a lot of community service in other ways, and it could be for clubs or by yourself. And that could come into an argument with the court as it relates to all of the sentencing. And it could be accepted perhaps, but with this, if you do convert it, it would be 10 extra days on the monitor So an extra $250.
Mr. Swenson has indicated he wants to pay the $250.
Okay, all right. Okay, so now that we have that settled and everything's going, we have an OWI third here. And I have your plea questionnaire and waiver of rights form along with the addendum to the plea. Did your attorney go over this document with you thoroughly?
Yes.
And he went over it essentially, basically word for word?
Yes.
And did you sign this document?
Yes.
You're pleading guilty to an OWI third offense. You are 47 years old. You have 12 years of schooling. You can read, write, and you understand the English language. You are currently not receiving treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours. Is that all correct?
Correct.
Did your attorney go over with you what the state would have to prove, as well as the minimums and the maximum possible penalties you face?
Yes.
Do you understand that because there are allegations of committing a crime, you are entitled to constitutional rights?
Yes.
You understand that those rights are on the plea questionnaire? And did your attorney thoroughly go over those rights with you?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
You fully understand them?
Yes.
And do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that as to count one, operating a motor vehicle while under the influence, third offense, that the state would have to prove on or around September 14, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, and this would be your third countable offense. Do you understand what the state would have to prove?
Yes.
Do you understand the minimum possible penalty could be a fine of not less than $600, but no more than $2,000, and imprisonment of not less than 45 days, but no more than 1 year in the county jail? Do you understand that?
Yes.
Do you also understand the court shall order an AODA, OWI assessment and driver safety plan and follow through?
Yes.
You also understand that the court shall order your license be revoked for not less than 2 years, but no more than 3 years. Do you understand that?
Yes.
Do you also understand that the court must also order an ignition interlock device to be placed on your vehicle during the revocation period?
Yes.
Do you understand that there is an agreement that's been reached and it's been recited on the record? But do you understand I don't have to follow that agreement?
Yes.
Simply said, I can sentence you to anything that I find to be appropriate under the circumstances, even if it's the maximum possible penalty.
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over that criminal complaint with your attorney?
Yes.
In particular, did you go over the probable cause section?
Yes.
And that's that part that basically says what happened and why you were charged with the crime. You remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today you in fact did operate a motor vehicle while under the influence?
Yes.
And this, are you admitting here today this would be your third conviction for operating a motor vehicle while under the influence?
Yes.
Mr. Anderson, may the court use the probable cause section of the criminal complaint and the statements made by your client to find a factual basis?
Yes, Judge.
Has anyone made any threats or any promises to you for you to plead guilty today?
No.
Are you pleading guilty freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he discussed the evidence and discovery with you?
Yes.
Has he discussed whether or not you have any legal defenses or a lack of defenses? Like, did he say, oh, it looks here like I think if we argue to the jury, we can do this. and
No.
this is
No.
Okay, so you don't, he talked to you about those?
Yep.
And do you understand, well, he talked to you about any defenses or lack of defenses. Are you satisfied with his services?
Yes.
You have any questions for the court or your attorney before I proceed?
No.
Then as to count one, operating a motor vehicle while under the influence, third offense, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. The court will find a factual basis to accept your plea of guilt, and that you understand the constitutional rights you're giving up here today. The judgment of conviction will be entered. Argument and sentencing recommendation, Mr. Schmidt.
Judge, we have these IDIP guidelines because it incentivizes people to do the programming beforehand that we believe makes them safer drivers in the future. It still has a punishment component in that it's very expensive. It results in a revocation of their license of some degree. And because it does have a jail component, even if that jail component for most of it's going to be on electronic monitor. He will still go to jail. He will still have that 48 hours that the legislature demands. But I think especially when we've had these days where we have a court with tons of OAR hearings where we see all the people who didn't do the driver safety plans, we see how beneficial for the community this sort of diversion or post-charging diversion really is. So I ask the court to follow the recommendation and give the defendant the benefit of the IDIP program. Thank you.
Thank you. Mr. Anderson.
Judge, Mr. Swenson got into the IDIP program relatively promptly. He completed it. And as I have no reason to doubt his discussions with Ms. Anderson, and of course, realizing she's not the one who makes the ultimate decisions. Mr. Swenson operates Sweeney's Bar and Grill in rural Webster. As he has said here, he didn't do any more than the required community service that had to be done. However, he is prepared to pay the extra fee for not getting community service, although as he's told the court here today, he, as the nature of his business, holds, shall I call them, charity raffles, where the profits from the raffles, if you will, go to, he mentioned the school district. He also made reference to the fact that he is president of the local snowmobile club and volunteers his time year-round for the various things they need to do to keep the trails accessible for when the snow comes, if it comes. But he also would need to make sure that the property owners are up to date with the easement grants that they may have given or seeking additional easement grants for any that they need to replace. That's an element of community service. He's not asking that that be counted, but I think what he's trying to make a point of is he's an active member of the Webster community and will continue that regardless of what the court may order here. If he chooses to do some other form of community service, he can work that out with Ms. Anderson after today even. On the night of his arrest, he was arrested in the evening, and he did spend overnight before he got released after midnight. So that doesn't meet the 48-hour requirement, but it is where he would get 2 days of credit. He also had his operating privileges suspended by the Department of Transportation, and that was for a 6-month administrative suspension, so he will get credit for that time. And what I'm recommending, and it's a little bit, it's over minimums. We are requesting that the court impose 45 days of jail. That's only 10 days less than the maximum. He's going to pay his fine in full as soon as we leave court here today. The revocation can be for 24 months, he will get the 6 months credit. What I am hoping the court will fashion would be IID credit, where he won't have to have the ignition interlock device after he may have his regular license back. And the court did say he would have to have the IID during his period of revocation earlier. And I would like the court to consider a 1 year or 18 month.
I don't think I can do that, quite honestly. I'm pulling up the statute right now. I don't think I can do that.
It's interesting. The IID is being ordered for as little as 1 year in many cases.
Not in my court, and I follow the law,
I understand that.
I guess, except
And
guidelines, but
it may be an issue that I may have to take up with the DOT, because he's going to get credit for the 6 months administratively. That is state law also. So may end up having to have the IID for the additional 6 months when he's back to his regular license then.
yeah, I'm seeing that there's no provision in the statute that would allow me to reduce the length of an order for an ignition interlock device lower than the mandatory minimum for any reason.
I understand. And certainly you follow the law on that, and it's pretty clear that is what it says. And I don't know if it's just creative judging in other places or not, but
Well, you can do what you can do until the Court of Appeals tells you can't.
right, that's what.
But I really do try to follow the law.
So anyway, we'd like to see a fine less than the 3175. We'd like the 1911, 45 days, 24 months IID and revocation, and the 75 hours of community service or payment or some combination thereof.
Okay.
2 days credit plus the 6 months administrative.
All right, thank you. Mr. Swenson, anything you want to add, you want to state here today?
No, I know I screwed up. I've learned from there, and it was just a bad evening. They're my family, and I'm raising 2 young girls, and it's changed, and we've have erased that night from my life, and I've been doing very well and being a good father and a good husband.
Mr. Swenson, I'm very glad to hear that. I do not want to see you in this court or any other court for a 4th offense, because then it strips your driving forever.
Yes, I know.
Except the caveat of after 10 years, you can try and petition, but it's very hard.
I've learned that talking with my counselor through the Aurora, explaining all that, and she's which I've completed, and that really helped me a lot talking to her. So
I'm going to tell you, and I know you understand this. I don't understand this personally, but my aunt owns a bar. She still owns it, actually. It's a different life. You are around alcohol 24/7, because let's face it, a bar really is kind of 24/7,
yeah,
even though you're closed some of the time. That's a big trigger for people to work and not drink if you have a substance abuse issue. Only you can determine to what extent alcohol controls your life. And if you're going to take control and start controlling your life instead of letting the alcohol do it. And I know I don't have to tell you, but I am going to tell you, because I do tell at least some people when I remember to say, the issue is not your drinking or your drinking in excess. 0.323, OMG, that's high. But I mean, my mom was a nurse, she saw higher, 0.5. So it's crazy that what the body can tolerate and build its tolerance up to. But the issue is not you drinking or you drinking to whatever excess you want to drink. The issue here, and the problem that you have at least 3 times now, is getting in that car and driving. It's your life, you make the choices, but then you have to suffer the ramification of those choices. I hear that you are a good community man, good father, you're trying to run a business, you're trying to be there and help the residents of this county in multiple ways. And I get that, and I understand that. We need more people, younger people of this age, not the, 70-year-olds, because that's dying out. We need more
Yes.
younger people to be involved in these types of events, because otherwise they're going to die, and then we're not going to have anybody doing them, such as how the Lions Club and the Lioness Clubs are kind of,
Yes.
they're suffering.
And I'm the youngest person in our Snowville club, so I know.
I know, and they suffer, and it's an issue because, I would love to do some of those programs. I can't, I just don't have the time. But I'm glad that you do. OWIs are very, very serious. I don't think I have to tell you, but I think we had a case where somebody left Sweeney's. I think a couple people did, and a kid got ran over twice by 2 cars, got hit by 1 car, then got hit by another car. Luckily, that wasn't you who has been in something that you didn't cause an injury or something to somebody else, or you didn't die, because you have 2 little beautiful baby girls that need their father. They need their father to be present with them and sober, and to step away from the bar sometimes.
Yes.
Because the bar, it really is your life. I know that. You're doing good things. You did the IDIP program, which is a lot, and you're getting your life together as it relates to the alcohol and that substance abuse issue. I don't think the community is at risk or at harm. You've learned a lot in the program, and hopefully, upon all hopes, you are going to install what you've learned into your life and continue that forever. Again, I don't want to see you get an OWI 4.
Oh.
What the court is going to do is, I can't guarantee or say that Miss Anderson told you a lower amount of time, and and Mr. Anderson knows that she's not a lawyer.
Yep.
She can't tell you what the sentence is going to be. But that's, if she did do that, then that's an issue for me to talk to her as her superior about that. In looking at all of the facts together and taking into account all of the information that's been provided to this court, what I am going to do is I will sentence you to 45 days in jail plus 10 days. So a total of 55 days. And I'm doing the lower guidelines simply because you are a community member that does a lot for our county and our community. And I believe that, you're going to sit 55 days anyway. You're just not going to have that community service requirement, but you are doing community service, not every day, but a lot of days. So that's why I am going to do the lower bracket. So it's $1,911 plus a $10 blood draw fee. You're going to pay that today, hopefully. Otherwise, I'm going to say you have 20 days to pay.
Okay.
Okay. I'm going to order 24 months of ignition interlock device and 24 months of revocation of your driver's license. I'm going to give you credit for any administrative suspension you've already received. And I'm going to state on the judgment of conviction in my decision here that if the Department of Transportation, the DMV, were to say that because of that credit, you don't need to have the ignition interlock device for a full 24 months. As long as I have proof of that, I'm okay with doing that. But they're the ones who essentially control that aspect. The law tells me I shall order 2 years at minimum. So it's 2 years ignition interlock device, 2 years revocation of driver's license with that credit. I am going to tell you though, I have never denied anyone, not anyone, when they apply for 50% cost for the ignition interlock device. So if you want to do that, you would see Amy, who is our traffic guru, and she can explain that or give you the form. Okay?
Okay.
Because to me, I don't care, well, unless you're a millionaire, I guess, but I don't care how much you make. I just want people to get that on, follow the law, do what they need to do, and get over that and be done. I have to order that you sit 48 consecutive hours, and it's an immediate report. You did the IDIP program, so I will give you the option to serve the remaining time on electronic monitor, which does monitor your skin and your sweat. So it'll detect if there's any amount of alcohol in your system.
Yeah, that's fine.
Plus, if you don't get gasoline or rubbing alcohol or mouthwash or probably cologne near it, because it will go off and give a false positive. I'm going to tell you right now, I don't listen to people's excuses of false positives. If it alerts that there's that it detected alcohol, you will be told you're immediately revoked and you must go sit the rest of the time in jail. No good time, no Huber. All right. Well, on the monitor, 2 days jail credit.
Yes.
And while on the monitor, absolute sobriety, no alcohol.
Yeah, that's fine.
You can go to work. You can go to church. You can go to the grocery store 1 time a week. Tessa will go over the policies, the procedures, and the limitations there. You can't do, community service, because you're doing it, that may be something that will be approved. You have to talk to Ms. Anderson, and then she'll send me a request, and I'll decide if that's appropriate. But you can't go to somebody's pool party.
Yes.
You must only throw your own pool party. People can come see you. You can't go to them. Do you understand?
Yes.
Anything else I'm missing besides the last words I have to state on the record as it relates to the monitor, et cetera?
Well, I'm sure he can work this out with Miss Anderson. He's a bartender. He works at his own bar and grill.
That's Huber, that's fine.
But he may get alcohol on him that spills or whatever.
No, that's his problem.
Cleaning up a table, so.
You just better be careful.
There, that's, well, I was going to ask that question also.
I mean, and
doesn't happen.
If you want to tape a bag, like if you have a cast and tape it over there while you're cleaning up, then that's what you got to do.
Okay.
Because if it registers, I understand that you do work in a bar and grill and you do those things. And I do understand alcohol spills, but do you see how I can't?
Yes, no, I understand.
Trust that's it.
Yeah.
I've been told so many things, and that's why it's like, nope, it is what it is. You'll be revoked.
I understand.
And then Judge, one more thing about the extra 10 days, that's for the community service. And what does he have to pay for that if he doesn't want the extra 10?
Oh, it would be $250.
Right.
And that would be
I
paid to Miss Anderson, and you have to prepay 30 days in advance for the monitor. Okay?
Yeah, I did. That's
done.
Okay. Yep. So that would be an extra $250. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, the court will enter a civil judgment against you. I will also issue a warrant. You could sit up to 6 months in jail. I need your DNA. You're going to have to provide that to the jail. They'll get it when they book you in. You have the right to request it be expunged from the system through a written letter to the Department of Justice, not to me, but to the Wisconsin Department of Justice. It's easy to do. If you want to do it, you can Google it or ask Mr. Anderson. He can show you how to do it. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Anderson.
I believe that covers everything, Judge.
All right, immediate report. What you can do is go to the clerk if you're going to pay your stuff, do your thing, talk to your attorney. But then once you're done, immediately go to the jail, get booked in, sit your 48 consecutive, and then you can be hooked up with the monitor, okay? Ms. Sangate?
Then jail, like go at the front and walk all the way around.
Yes.
You come up here, I have your minutes.
Want to take this up too?
Court does call the case of the people versus Paul Ledford.
Ashley Feltus for the people.
Just in a row. Your name, sir?
Ledford.
Mr. Ledford, you are before the court on a misdemeanor complaint that alleges that on or about March 4th, 2026, at the location of 3362 Bent Trail Drive, Pittsfield Township, Washington County, State of Michigan, that you did break and enter a premises or that you committed an illegal entry without the owner's permission. Do you understand the nature of that charge?
I've never broken into any place this year.
You understand?
So I would not
understand what you're charged with in this case.
Why would I be charged with something I've never done? I'm not even supposed to be in here for the last 3 months because disturbing the peace. I was on that side of a perimeter where there's no
Sir, I don't want you
installation. I never
about the sir. I don't want you saying anything about the case. I just
never did.
I need you to know whether the charges you believe are legitimate or not. I need you to understand what you're charged with.
No, you not understand what I'm charged with.
You don't understand.
Charged with it.
Are you telling me you don't understand what you're charged with?
That's what I am.
Okay, then we'll do it this way. Sir, you are before the court on a complaint that alleges that on or about March 4th, 2026, at the location of 3362 Bent Trail Drive in Pittsfield Township, Washington County, State of Michigan, the complaint alleges that you did enter with or without breaking a house located at that address,
with no
whether occupied or unoccupied,
right. So you can just
without first obtaining permission
a row
premises
and I just keep getting charged
from the person having control thereof. Do you understand now what you are charged with, sir?
No, I do not, because I was nowhere even near there. Why don't you look on the
Doesn't matter whether or not
like that.
Sir, you need to stop.
You need to stop charging me with charges where I was
I'm not charging you with anything. I'm letting you know what you are charged with.
like disturbing the peace when I'm way on that side.
Do you understand what you are charged with?
Yeah, I get paperwork and all this.
What I'm gonna do is I'm gonna adjourn his arraignment out. You can take him back. This is the matters adjourned to August.
Yeah, I get paperwork.
Take him out of here.
There's no crime.
Get out of here. Have a great day.
You want my paperwork?
Court does call the case. Well, they probably are delayed. Isn't Mr. Ledford up on my PCC docket?
He is, Your Honor. He's pending competency.
Yeah, okay. Should have led with that. Okay.
I didn't get a chance. I'm sorry, Your Honor.
No, it's okay. It's all right. We'll figure it out in some. Court calls the case of the people versus Nicole Henderson.
Ashley Feltus for the people.
Morning, the lawyer, and I apologize for my tardiness. I'm so sorry to the staff, the prosecutor, my client, Nicole Sadi. I represent Ms. Henderson. She's present today, standing right next to me.
State your name.
Nicole Henderson.
Thank you. All right, what are we doing?
I had a chance to go through the discovery. I know that Mr. Cook had worried that one of the videos wouldn't play. All of the digital media plays for me. Having said that, I was looking to see if there were specifics regarding the actual testing on the body-worn camera, but I don't have that covered. So I'm going to be requesting some more information from the prosecutor's office after viewing the video regarding the testing methods. I understand there's no offer on the table.
Testing.
The blood testing. I also wanted to clarify, Your Honor, I believe the court asked probation to go ahead and run an intake for my client through sobriety court at 14 time. I wanted to confirm.
I don't know that I don't have a referral. Ms. Lundy, you know anything about additional evidence regarding the testing?
I do not, Your Honor. I'm terribly sorry. I wasn't entirely clear what defense counsel meant, so I'm not sure what the request is for.
So when I did my research, I was looking at MCL 333-16215, the qualification of the person drawing the blood. I was also looking at, it looks as if the administrative rule, it's ACR 325.2675 rules blood testing. And the case law, and I was going to write this up for Mr. Cook. The case law shows that we have to look at the time it was taken, which identified body, whether it was an authorized licensed doctor or a med tech or RN.
All of that's in the police report, isn't it? Who drew?
I don't believe so.
Your Honor, I'm looking at the police report. This is Pittsfield Township Police Report 26-7981. And I will also, for the record, note that I'm standing in today unexpectedly, so I apologize for not having more familiarity than I have right now. But it does say that the police officer arrived with the defendant at Trinity Health at 0048 hours. There was a delay, and then when the blood draw was done, it was conducted by a nurse. The nurse is named under the direction of a doctor who was also named. The blood kit is given with a lot number. I am very familiar with the administrative rules, and I'm very familiar with the blood testing requirements for OWI cases. And I think that there does appear to be a lot of information within this report. So, not sure.
Could you please, and I may have missed those particular items, but I was just going through the rule myself. Could you please tell me which page number you're on in the report?
It's under the section marked blood draw, page 10.
Oh, I do have a name, so I will correct my earlier statement. I had seen nurse, but I have names in what would be the second full paragraph on that page. Yes, I do have the lot number. That is correct. When I was looking through the admin rules and the list that I have, I'm looking at a couple of different things: method and procedure for transport, methods for conducting tests. At the same time, we do want Ms. Henderson to do an intake with the sobriety court. So I don't want.
Have I resolved whatever your discovery issue is?
I don't think so. I'm going to put in a written request, Your Honor.
Okay, but what's the written request for?
Well, when I'm looking at the case law, I have a total of 9 elements that are supposed to be used. Whether it was properly preserved or kept, the method and procedure for transport, the method and for conducting tests. I don't mind giving you the case that I took this from. It is.
I'm very familiar with the cases involving that. What, though, are you asking from the people? Because I'm not going to have you come with a motion saying they're not complying with something.
Well, I'm actually looking for information on whether or not it was complied with. I understand MSP uses gas chromatography, but it looks like the actual transport of the blood is one of the factors under the case law from when it was taken forward to the testing agency, to Michigan State Police. I guess that would go along with what we think of as chain of custody. The properly preserved and kept is actually separate here than the method used for transport. So there's more information to be had there. So I don't know that I do have a challenge yet. From what I'm reading, this information needs to be supplied, and then there I can tell if I have a challenge.
And Your Honor, like in every OWI case I've ever seen with the blood draw, the laboratory report from the Michigan State Police indicates the date that the item was received, the date that the report was completed, the date that the report was released. It also the Pittsfield Township Police Department Public Safety Report also indicates that the items were sent to the Michigan State Police. From a quick review of this case, there doesn't appear to be anything missing that I can see at a quick glance, nor does there appear to be anything exceptional or strange. I know the court's familiar with the preservative within the tubes for the OWI blood draws, and that preserves the blood samples, so they do not need to be refrigerated, and they can be transported in the United States mail. That's an acceptable way to transport blood samples. So it appears that everything that I can see looks good here, but if there are specific requests that can be sent offline and addressed not during the docket, I'm sure Mr. Cook would be happy to look at those.
I do have a specific request I'd like to put in for Mr. Cook.
Adjourn it to August 5th, 2026, 9 a.m. or as your invite indicates.
Brother, I did have a question regarding your court procedure. I don't know if that's something you would like to do off the record or on the record.
Oh, no, everything we're going to do on the record.
Okay.
What is it?
My client is requesting to go out of town for one weekend in August. She has provided me with some travel plans. I would like to go ahead and put in that motion. I don't know if Your Honor would receive it informally through an email, if you would like me to file a formal motion with the court.
Trying to go.
It's a Christian travel retreat in Atlanta. She would be at a Hilton at 255 Cortlandt Street in Northeast in Atlanta, Georgia, from August 14th to August 16th.
People have any objection?
Your Honor, what is the current testing order from Ms. Henderson? I know that she was released, and I know the court knows that she's got a significant alcohol history, so I just wonder what her testing is right now.
She is currently on a scram tether. I can see it from here.
Excellent. I don't have that advantage, Your Honor. As long as she remains on the tether and she remains compliant from now until the dates of her travel, I have no objection.
All right. And that was August, what date?
The 14th through the 16th.
And have you gotten yourself enrolled in non-farm?
So I have intake with my job tomorrow at 8 a.m. And
you have what?
The intake with my IOP.
Okay.
Tomorrow at 8 a.m. So even though Don Farms was my idea, I was gonna ask, can I renege on that? Like, that's a lot. So,
what is the lot?
Because through my job it's 3 times a week for 3 hours, and then Don Farms they said it was in person. I know you said that.
I did. Nobody wants to listen to me. That's fine. I said, you want to do all that? I'll let you do it. But that's all right. So your intake for the resources through GMUAW
8 a.m.
tomorrow, 8 a.m. tomorrow morning. Okay. And that's Atlanta.
Yes.
The 14th through 16th, that includes your travel?
Yes, that's Friday through Sunday.
Is mom going with you?
Yes.
Is she going with you?
No,
I don't know. She let you out on your own.
Huh?
Oh, okay. All right. Well. All right. Here's what I'm going to do. Provided the defendant is compliant with her bond requirements and enrolled in her IOP, then I will permit her to be able to travel to Atlanta, Georgia, August 14th through the 16th. Yeah.
Could I also have a copy of my bond requirements? I didn't get it right on John. Can I have it printed out?
You don't know. You don't know.
No, I know. I know.
You don't know what you're supposed to be doing?
I know what I'm not supposed to be doing.
Okay. All right. Sometimes that's as good as anything, right? Okay. Well, your bond, yeah, you can get a copy of your bond requirements up at the front. The things that I added on release is that there was a scram tether prior to your release. And I put rolling Don Farm and GM employee program. I'm not going to have you do both because now you understand why I was. Yeah, I know what you were trying to do. You were trying to do anything you could to get yourself out. I hope, and the way I took it really was your acknowledgement that you have a problem that you have to address, right? And you're willing. I took it in a good way because I think what you're trying to do anything and everything you could to try to address it. So, all right. So I'll allow that travel. I'll take that one condition of Don Farm out. All right. But if for whatever reason the IOP isn't working out for you, you still have that as an option.
Okay.
Okay. All right. And was that it?
Would you like me to prepare the proposed order for travel?
You can. What was it about the referral to sobriety court?
So I heard that what went in. I wasn't sure my memory. I remember you speaking to the probation officer about her eligibility for sobriety court, and I wasn't certain if she had also put in a referral yet. I wanted to follow up.
I don't have a referral. Usually there's an intake done, but
From Ron Brown, he had brought it and had made me sign it.
Sign it.
Next day I had her, so I wasn't sure if he gave it to her or submitted it at all.
He did not give me any.
He probably did not submit it if that's what happened. That's the timing of it. I can say this, certainly you can go through that and I'm not going to have any objection. I don't have any problem with that, but the only issue is, did you take care of the other matter?
Yes.
So, yeah, she has appeared twice for Shelby Township. She has a court date for Clinton Township on the 20th. I went ahead.
That's the OWI.
Yes.
That's out there. So you're dealing with that.
Yes.
Okay.
My warrants have been handled.
Huh?
My warrants have been handled.
Okay. Yeah, I get that the warrants have been handled. I think the issue may be with sobriety court that you've got this other thing pending out there. Right. And they probably, I would think, I'm not going to speak for them, would probably like to see that resolved. And then this resolved as part of that whole thing. Okay. All right. Anything else?
No, thank you.
On, continue.
Drew Aaron Gerald Jr., 26B, 1502441A and B. Mr. Gerald, your name?
Drew Gerald.
I placed you on probation under section 7411 on May the 7th of 26 on a drug case. I also placed you on probation on that same date for operating while impaired. And I here now have in front of me a violation of probation. Yeah, I think Mr. Teo's on that one. I have a violation of probation that alleges that you on count 1 failed to pay your fines and costs as ordered, the rate of 75 per week. Count 2, that you failed to refrain from consuming alcohol or drugs. Count 3, testing positive for amphetamines. Count 3, failure to provide verification of attending AA twice a week. I'm sorry, 3 times per week until an outpatient. Count 4, failure to provide verification of attending and completing outpatient treatment. Count 5, provide proof of completing community service by June 30. And count 6, failure to clear all warrants by July 1 of 26. You understand each and every one of those charges?
Yes, sir.
On count 2, the same 6 charges exist. Count 2 is the controlled substance charge. If you plead guilty, if you understand again all the charges.
Yes, sir.
If you plead guilty, if you're found guilty, your probation in this case could be revoked. you'd have more than 3 technical violations, you could get 93 days. And also, your drug charge, 7411 status could be revoked. And that conviction entered on your record by virtue of the violations here. You understand all of that?
Yes, Your Honor.
You sign, read, and understand the advice of rights. If you plead guilty, you'll be giving up all those rights, and we're not gonna have a trial of any kind. You understand that? All right. You do have the right to a lawyer. I'll be happy to provide you with one at public expense if you would like one.
Yes, please.
Would you like a lawyer?
Yes.
I'm entering a not guilty plea for you. Hang on 1 second. I'm indicating you stand mute, entering a not guilty plea on both of these. Did you have a question?
Well,
I don't want you to talk about the case. You just asked for a lawyer. I want you to talk to your lawyer about the case before you talk to me about the case. Do you want to say something or ask the question? I don't want to talk about the case.
it's just about money.
I don't want to talk about money.
Okay.
Okay? Your lawyer can address all of this with you, okay? Fair enough?
Yep.
Good enough. You go out in the hallway, I'll set you up with a lawyer.
All right. Thank you.
I'm entering a not guilty plea on these. Thank you. Drew Aaron Gerald Jr., 26B15024-1A and B.
No, that's fine.
Good morning, Judge Bianca, TOP 8237A, on behalf of Mr. Jarrell, station employee.
Drew Aaron Gerald Jr.
He's got 6 counts. We have 1 conviction for operating while visibly impaired. We have another charge, a drug charge that was taken under 7411. That was for cocaine. And he has 6 charges. I arraigned him on the charges. He indicated he wanted probation violation charges, I should say. He said he wanted a lawyer. I've appointed you. How we doing here?
So, Your Honor, he would like to plead guilty to the allegation with an explanation for each.
I can't wait to hear it. You understand everything I've told you so far, right, sir?
Yeah.
You understand that you would now have the opportunity, I'm just saying, with 6 violations. You could have your probation revoked and you could be incarcerated on this for up to 93 days on the impaired, 7411 status revoked on the drug charge, and you could get 90 days on that. Do you understand that?
Yes, sir.
And knowing all that, you still wish to plead guilty.
Yes.
And you just sign, read, and understand an advice of rights form in this courthouse today.
Yes.
You understand? If you plead guilty, we're going to be giving up all of those rights. And we're not going to have a hearing or a trial of any kind. Do you understand that?
Yes, sir.
All right. Now, as to count 1, to the charge you failed to pay fines and costs as ordered on both files, I told you to pay $75 a week. Last payment made, it says on June 1 of 26. How do you plead to that?
Guilty.
Did you fail to pay your fines and costs as ordered?
Yes.
Count 2, that you failed to comply with probation in that you failed the chemical test on May 27 of 26, testing positive for amphetamine through onsite. How do you plead to that?
Guilty.
Did you in fact test positive for amphetamine?
Yes, sir.
And you didn't have any prescription for anything, correct?
No.
All right. Count 3, that you failed to provide verification of attending AA 3 times a week until an outpatient treatment. How do you plead to that?
Guilty.
Did you fail to attend AA 3 times per week?
Yes, Your Honor.
Count 4, that you failed to provide verification of attending and completing outpatient. How do you plead? Outpatient treatment with aftercare. How do you plead?
Guilty.
Did you fail to do that?
Yes, sir.
Count 5, that you failed to provide proof of completing your 8 hours of community service by June the 30th. How do you plead?
Guilty.
Failed to do that.
Yes, Your Honor.
Count 6, that you failed to clear all warrants by July 1 of 26 is ordered. How do you plead?
Guilty.
Failed to do that.
Yes, Your Honor.
Anybody force you to plead guilty?
No.
All right, John, I'm going to need Madeline in here. I'll accept your plea of guilt to all those charges. I find they have been made voluntarily and understandingly and are accurate pleas, so the plea is accepted as follows. Count one, the failure to pay fines and costs is ordered. Count two, failure to test negative, in other words, positive for amphetamines, add a chemical test on May 27th. Count three, failure to attend AANA 3 times a week. Count four, failure to attend outpatient treatment. Count five, failure to attend community service. And count six, failure to clear all warrants by July 1. Your name?
Madeline Rockets, probation governor.
You got your work cut out for you, Ms. Patillo. What's going on?
So, Your Honor, as it relates to the outpatient, Mr. Jarrell had found work. He's been working at VidCon for about 3 weeks doing sheet metal for the local 80. The reason that he didn't do that is because he was looking for a place to do it virtually, which would go along with his work. He did find a place to go to, but they had copay, and at the time he couldn't afford that.
When did he acquire his employment?
It was 3 weeks ago.
Yeah.
Was he going to AA the whole time?
No.
I thought I said to go to AA when I sentenced you on May 7th, 3 times a week until an outpatient.
You did.
And now you're saying you got work 3 weeks ago, which would put us at the latter part of June. And that's why you didn't go to outpatient, because you didn't have the time now. But yet you didn't go to AA 3 times a week, right? Am I missing something? I just want to make sure I understand. Is that true? Yes, right?
To an extent, I mean.
To an extent. Well, to what extent?
When I had the time, I didn't have any money. I mean, I
It doesn't cost money to go to AA.
Well, no, it costs money to put gas in my car.
Did I tell you? Give me a break. Did I tell you to call the court and go on Zoom with me if you didn't have the money to pay?
Yes, Your Honor.
So
You had the money to use drugs. He's got a problem. Go ahead.
Well, the positive, and I
Can't wait to hear
don't want
that.
to misspeak, it was the Adderall pill that he had gotten from somebody at work. So it wasn't, he didn't purchase.
I see. So somebody else passed along an analog, contrary to law, and he took it and he ingested it.
Yeah, it was stupid. I made a bad decision.
After the warrants, the same thing with the money, Judge. He didn't have the money. I know.
I can forgive the money. I don't forgive the fact that he didn't call, but I'm not even worried about the money. I'm worried about the fact that he's testing positive, isn't in treatment, didn't do his AA, didn't clear his warrants. He didn't do anything. Did he do anything?
No. So I would say it is my understanding that this is an 18-month probation. He was just put on probation May 7th, 2026. I would ask if the court would refrain from revoking the probation or any jail time while he was given dates to complete everything. He knows that. It's only been about a month and a half. And it is a struggle when you don't have a job and when you get a job and you try to keep that job. So now he understands how serious this is. That Your Honor could revoke probation, but I would ask if the court would allow him to continue on probation now that he has work and money. He should be able to take care of something.
Can I see the screening report? I don't just order AANA nilly-willy. There was something in this report that told me I needed to do this. I obviously didn't do a very good job. You didn't think, you're not listening to me at all. You were using cocaine, getting behind the wheel.
Stupid.
What do you think?
I mean, in terms of not having a job, I do understand. However, Mr. Durrell was driving to school daily. It was a pretty far drive from what I recall, because that's actually why we missed our first appointment, is he was driving on the freeway still. So it would be easy to stop at a meeting on the way or on the way home. So I am very concerned because at this point, There have been no efforts made, nothing spent. Completed. And he hasn't communicated with me at all, and, issues or anything.
Just the school was actually for his work. I don't know if that makes it any better, but again, Judge, he was just put on probation May 7th. I would ask if the court would give him a little more time just to be compliant with at least some of this stuff.
If you'd done some of it, I could listen to that. You did nothing.
Did pay a decent amount of fines, I believe. I shouldn't be that far behind, I don't think. Maybe 2 or 3 payments.
And he also brought $500 to me.
Yeah, I do have money now, but
Good, you can apply that to your bond or to your fines and costs. I'm not gonna order it any extra costs. You are, however, I'm gonna keep you on probation, subject to all existing terms and conditions. You're to serve 6 days jail forthwith. You have 21 days to appeal, 14 days to apply to the lawyer for purposes of appeal. Hope this doesn't cost your job, but I didn't, you will. If you have completely ignored orders, you're on a short leash with me, sir. It could have been a lot worse. Have a seat in the jury box. Good luck. Jean Louise Trozine, 205I-2886. See, now I just love these. Ms. Trozine, your name.
Junie Garcia.
Remind me, where have you been for the last 21 years? Well, I want to go back 21 years in time. You know how young I'd be? I'd be almost as young as Mr. Carmen.
almost.
So I was on crack for.
Okay, well, fair enough. At least you're honest. You're gonna plead to impeding traffic, right?
Yes,
Did you post a $200 bond
yes,
to impeding traffic charge, responsible and not responsible?
responsible.
How do you support yourself now?
On Social Security?
Tell you what, at least you were honest. I'll make it 150. We'll reimburse $50 for you, the bond. And,
Judge, she
We're
does
gonna-
have a clearance fee also.
okay, so you got a clearance fee of $5 or $45. So you're gonna walk out, not today. They'll probably have to give it to you tomorrow. I don't know. We got a lot going. So you make sure you take care of your clearance fee. That'll be $45 plus the 150, and we'll reimburse you for the $5, okay?
Okay, when do I have the clearance fee?
You don't have to. We're gonna take it out of your bond right now.
Okay,
Is that fair?
yes.
Is that bond in her name? It is, right?
Yes,
Okay.
it is.
Go down and you can deal with them, okay? Thank you.
Shannon Phillips, I don't have that one. I gotta check to see what it is up.
What's your name in the back, standing up?
Just the game,
What is it?
just the game.
Just good, Dan.
Wow,
She's time to pay.
I can give you time to pay. Is that what all you want?
Yeah, I have it right here.
Jeez. Somebody showed up. Come on up here, man. Jessica Daniels. 26W8411907. When was she supposed to pay, Heather? Your name?
Just the games.
When was she supposed to pay?
Let me take a look. I'm pulling her up right now. Which case number was that, Judge? Because she has a couple.
No problem. 26W841-907.
It looks like she missed a hearing with us back on May 11th, so it defaulted.
Right. Okay. How much time do you need to pay this?
Well, I have 2 questions. It's not complicated, but I have 2 other questions.
Well, tell me quick.
Okay, is there a way that I can get a motion to waive the bond?
No, I'm not
What's your
gonna,
call?
the court rule says I'm supposed to, assess the amount of the bonds to be total payment of fines and costs.
Okay, because one of the tickets.
So the answer to that question is no. You're gonna have to post $198, which is the outstanding balance.
Because one of the tickets I'm currently in.
I only have one ticket,
Oh, it's two.
not in front of me. Yeah, you do have another one. Jessica Daniels, 260084443.
So
This,
the hearing that I missed, I had.
man, you have to go post a bond. I'm not gonna do this. I'm sorry. If you want time to pay, I can give you that. I'm not gonna waive the bond post. Okay.
I was just saying, I missed the court date because.
I don't need to, I don't need,
For that, for my.
well, you needed to tell us. Who's got the phone? You gotta take the phone out, please. Will you do that for me? We got signs all over the building. I'm gonna ask you to remove the phone from the building. Ma'am, thank you. I don't know what to tell you. You missed court dates. If you had a, hang on. If you had a conflict, you needed to call. You can't just come in here and ask me to start waiving bonds on judgments that were entered back on May the 11th. And I'm not going to do that. I'm not going to waive the bond amount.
I understand. I was
Okay?
just saying that the ticket for the registration is currently in litigation because I was in an accident.
Litigation.
Yes, we're in
Hang on.
litigation right now.
What does that have to do with it?
For the registration. I got a ticket, that's not my fault. We were in litigation. I was in an accident.
Well, hey, folks, can you please all do me a favor?
So I can't.
Get the phone out of the building right now. Take it out of the building right now, or I'm gonna confiscate the phone. We got signs all over the building. It's common courtesy to turn them off when you come in at a place like that. We shouldn't need a single sign anywhere in the building, and they're all over. Get the phone out of the building or I'm gonna confiscate it. There's nothing for me to say.
I understand. I was just saying that.
No,
the registration.
no,
I
no.
can't do anything.
Ma'am, that's not true. That's not true. Litigation, what are you getting sued for something? I don't know. Ma'am. I'm not gonna entertain you. I'm not gonna argue with you. You have to post a bond. If you don't post a bond, the default's gonna remain in effect. I'm not sure you've given me any single reason to set it aside to begin with, but I don't wanna continue on this little colloquy here that we have going, okay? Please. You want to move to set aside those, you go down and post the bond. If you need time to pay, I will give you time to pay. You need time to pay.
Sure.
How much time do you need?
3 months.
I'm not gonna give you 3 months. Do you work?
Not right now.
Why not?
I was trying to explain to you.
All right, listen,
I was in a car
listen,
accident too.
listen.
So I'm not able to work at the moment. I have injuries. We're in litigation. It's a lot going on.
Don't argue. Don't start with raising your voice with me. You weren't in an accident arising out of this expired license case, right?
I was.
They didn't say anything. Just says stop for, let me just read. Stop for 35 and a 25. So the officer thought you were speeding, cut you a break, wrote you for expired plate. Passenger side tail light out. Plate expired on February 28 of 25 and no insurance. Wow, he should have sent you a Christmas basket too. I mean, if he was that nice, when you didn't have insurance, defective equipment, and speeding 35 and a 25, and not having a valid plate, and he only wrote you for expired plate?
Your Honor,
Hang on, don't interrupt me. Do not interrupt me. Do we have each other? I'm not going to listen if you interrupt me or raise your voice with me. Do we understand one another? I can't hear you. You don't want to answer? You didn't say anything.
That's why I was speaking louder because you can't hear me.
I can joke about my hearing deficiencies. You can't. Okay, I can hear just fine. There's not a single word that you said to me that I haven't heard. You didn't say yes. You just kind of looked at me like, I don't like what you're saying, and I'm going to respond. Here's this. This is the end of the conversation. I'm gonna give you an extension to pay on both of these until until September 15th. That's it. Heather, make a note. I'm not setting aside the default. I'm not waiving the bond. I'm not gonna do any of that. And this has nothing to do with an accident. You tell me you're involved in litigation, and I'm sorry. That is not what the case is. So Heather, will you please get these folders together? I'm giving her until September the 15th of 26 to pay. Thank you for showing such respect. Have a great day. Oh boy, I could be golfing Mosley today.
Oh boy. We could all be golfing lazily and badly today. Well, if we cared about golfing, we played golf on the Xbox. She is contemptible. That was wrong. You don't walk out on a judge when he's still talking to you. Ladies and gentlemen, that is the moral of today's story. Judge McNally had every right to throw her butt in jail for direct contempt of court, but you know, what you gonna do? Rude people are gonna just rude. Horrible. Miss Natasha Kitty, thank you so much for all your jewels and thingamabobbers. And Northwest, thank you too. Marty Duvall, Wendy Greek, Catching Chaos. Thank you so much for your support. And Vegas, you're slipping one in right there at the very end. Look at you. Same time, same Wolf channel. We will have more where all of this came from, presumably, as long as I draw breath and have the ability to do what I do on a daily basis. Because all of these court cases that you have been watching in this presentation happened on this very day, just earlier today. You may have seen some of them some other places. No place is quite like this. With this amazing chat right over here, ladies and gentlemen. You guys are the best. If you heard anything in the conversation tonight, any of the cases that you want to talk about them in the comments below. That's what we're here for. It's a conversation that never stops. In the meantime, we're going to say thank you to a whole lot of very special people that are scrolling on the screen right now. Catching Chaos, Vegas Starlight, Darth Steven the Objectioner, and Kieran. Darth Steven the Objectioner coming in at the late minute with the $2 super chat. Dude, thank you for that, my buddy. There's no objections to Darth Steven. I got nothing witty. I thought I had something witty. OSG was in here tonight. That's always good to see. Thank you for dropping by, OSG. And we had a lot of people in here from the Courtroom file. I know I was just catching Chaos. I'm thinking of you right now. Probably a few others too that, oh my God, I suck at this. I really do. You guys rock hanging out with me. I'm so, oh my God. I gotta show the world this. Cody May, look at that amazing super chat right there. Have a great night. You have a great night. Holy moly, and thank you, Cody Main. Coyote Main 42. Awesome handle. This channel operates entirely on the generous contributions of viewers like you. Thank you so much for that $20 super chat, my friend. I am your Lone Wolf Usul. I put together all of these videos and these compilations every single day for your perusal. Come on by next time. There'll be more where this came from. For now, I am out. And remember, only you can take a bite out of crime. Bye.